العالمين وصلى بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد وعلى آله وأصحابه وسلم تسليما كثيرا. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. اللهم لك الحمد على ما أنعمت علينا من نعم لا تحصى يا رب العالمين. فنسألك اللهم إتمام النعم وتحقيق المنن وأن تجعلنا من عبادك المخلصين برحمتك يا أرحم الراحمين. So we ask Allah subhanahu wa ta'ala to guide us to what is right and correct. Just to review, there's a couple of questions. What if you got money from the same seller? You were given money being fake in return. So fake money would make the transaction so what happens in a contract where the payment was fake? Sadati? What happens in a contract where the payment was fake? Sadati? So if the payment was void, so I purchased a phone for something that, and the payment, the thaman, was not mal. What would happen to the transaction?
Would it become suspended?
Go ahead.
Suspended?
Yeah, it would be fasid, right? البيع بما ليس بمال would be fasid. So it's voidable, right? The contract would either have to be cancelled or corrected. It would have to be either cancelled or corrected. So that would be the ruling, that the contract would have to be cancelled or corrected. So, and the same thing would apply with counterfeit money. Counterfeit money is not considered money. So we would deal with it accordingly, right? We would deal with it accordingly. Tamaman. So today we're looking at lesson number 16, which is on Kafala, on guaranteeing a contract. And this is something that is very facilitative, right? Because if we look in the Bada'i' al-Sana'i' and other works, Kafala, or guarantees have various benefits. What are the benefits of Kafala, Sadati? What's the benefit of guaranteeing a sale or a debt? Or what would be the benefits?
Facilitation.
Hmm?
Facilitation.
Facilitation for whom?
People who are less means or less well known.
Yeah. So it facilitates firstly for the one who's taking on the debt, that this would give confidence to the one selling to them, the one financing for them, that they would be able to fulfill. So it helps them. Why does it help the one who is giving the debt? Like selling the item, for example, right?
They may be unsure if one can pay it back. So then if you have that guaranteeship, then it's kind of a way of, okay, I know I'll get my money.
Yeah. It insures them, right? So that it secures their debt, right? So it prevents harm from them. That in the event of non-payment, they would be able to recover their money, but also gives them confidence to make the transaction. Right? It gives them confidence to make the transaction. Right? Because otherwise, if all transactions were risky, then they would not enter into it. There's merit in kafala in that, we as Muslims, we are encouraged to engage in financial transactions, right? And in business and in trade. So being a guarantor has merits. But it comes, of course, with the cautions that only undertake it if you are committed to fulfill. Right? If you are committed to fulfill. And the fact that we are distant from a lot of these things is because we are distant from a lot of economic activity as believers. Right? And we are too dependent on economic systems around us that are not in line with our religion and its values. So we ask Allah subhanahu wa ta'ala for steadfastness and success, and that He grant us understanding. Tamaman. So we will proceed bidhnillahi ta'ala by looking at this section. So the first part, we're going to look at the introduction and the categories of the guarantee, of the kafala. So here we have a couple of governing considerations, right? The legal basis of kafala is discussed in the classical works, and you can see in item 612 of the Majalla, it explains what the kafala is. It's a similar definition to what can be found in the text, but it's a little more detailed, so you can read that. But basically, in the kafala does not transfer, the guarantee does not transfer the debt to the one guaranteeing, to the kafil, but rather they become accountable for the payment, right? They become accountable for the payment. So it's al-kafala dammu dhimmatin ila dhimmatin fil mutalaba. It's to add another person to the dues with respect to the demand for the debt. And if the guarantor then covers the debt, what right do they have then? If the guarantor covers the debt, what right do they have?
To get their money back, to seek their money back.
Yes, they have the right to seek the money back if the guarantee was done on behalf of the person they guaranteed for. So you have to keep that in mind. So for example, if Sidi Masir purchased a residential property, a residential building as an investment for $10 million, and without his requesting, and it's payable 10 years from now. So year 10, Abdul Latif comes and decides to guarantee, or Abdul Latif convinced the guy, let Masir, purchase it from you. I'll be his guarantor. But without Masir requesting it. The transaction was completed because Abdul Latif guaranteed the transaction, but without Masir requesting it. So 10 years pass, and then Abdul Latif makes the payment on behalf of Masir. In court, can Abdul Latif seek the payment from Masir? No. Because it has to be, that the guarantor is contractually guaranteeing on behalf of the one who owes the debt. Right? Otherwise, it's just a unilateral thing. Uncle Latif voluntarily covered the debt. Now, diyanatan, religiously, if it was obviously the debt that he owed, etc., that would be a different thing. We would advise that that Masir, please pay Uncle Latif back. But it would not be a contractual, it would not be a duty, right? So for it to be established, as you see in this quote from Al-Kasani, the integral is for the guarantor to say, I am a guarantor on behalf of so-and-so, right? Because لأن الكفالة شرعت وثيقة. It's come to secure the fulfillment of the due. But it has to be accepted by the one you are guaranteeing on the base, on behalf of. Tamaman. So this is just this point of the Majalla is useful. And in the Mabsut, it states that the merits of the kafala, that it fulfills the interest both of the one who is giving the debt, right, like selling the item deferred, for example, and fulfilling the need of the one in debt, right? Yeah, they refer to it as matlub, which is al-madin, the one in debt, so that they wouldn't get in trouble. So that if the debt wasn't fulfilled, the guy's chasing after him. There's someone who can cover their back, right? They can cover back because someone could get into difficult times, etc. Right? Someone could get into difficult times, etc. Tamaman. That's one of the considerations here. The legal basis for kafala is that it has come in the Quran with respect to, from Surah Yusuf, right? وَلِمَنْ جَاءَ بِهِ حِمْلُ بَعِيرٍ وَأَنَا بِهِ زَعِيمٌ. And Za'im means kafil, and I will be their guarantor, right? From Surah Yusuf, verse 72. Ibn Abbas explains Za'im meaning kafil. Okay. And there's various hadiths, amongst them the words of the Prophet ﷺ, الزَّعِيمُ غَارِمٌ, right? That the Za'im being the kafil is liable. Gharim meaning liable, right? Right? So that if the asil does not pay, the guarantor has to cover the debt. And this hadith is related in Abu Dawood. And so similarly, there's a hadith in Bukhari when there's a man who had a janaza, whose janaza came forth. So the Prophet ﷺ asked does he have a debt? So they said, yes, he's in debt. So the Prophet ﷺ said, I will not pray over him because he is in debt. So Sayyidina Abu Qatada said, أنا الكفي أنا أتكفل به. I will be their guarantor. So the Prophet ﷺ agreed to pray over them. So there's several lessons in this, as you can see from the hadith explanations, right? One, of course, is the gravity of unnecessary debt. They say one of the reasons would have been, why would the Prophet ﷺ not pray over someone in debt? Why would the Prophet ﷺ not pray over someone in debt? To teach a lesson, right? That taking on unnecessary debt is إضاعة حقوق العباد. Taking on unnecessary debt is squandering the rights of others, right? Squandering the rights of others. And squandering the rights of others is a grave matter. That's number one, right? And number two, warning against taking on too much debt oneself, because it disadvantages one in one's dunya and disadvantages one in one's akhirah as well. And it's a matter displeasing to Allah. Unnecessary debt. Good debt, which is debt that facilitates for you to pursue your responsibilities in life. So you take on permissible debt to be able to facilitate an education, etc. So that's a separate matter. But in situations like this, it's not a good, like taking on unnecessary debt, the Prophet ﷺ warned against it, right? So this is one of the lessons from the hadith, but also you can guarantee for someone after their life, right? You could take on someone else's debt. So there's a number of lessons in it from this. Alhamdulillah. So we're going to look at some key concepts, right? And we need to be clear about these. And this terminology, don't get lost in it. And this is an application of Arabic grammar. So kafala itself is the guarantee. The guarantor is called kafil. This is from the fa'il pattern. The fa'il pattern is often used for the fa'il, right? The fa'il pattern in Arabic is frequently used for the fa'il or for the maf'ul. But here, kafil, what does it refer to? It's the fa'il. The fa'il, the one who guarantees, right? The guarantor is called kafil, right? Kafil bima'na al-kafil, the guarantor. The one who is promising to cover the debt, number one. The makful bihi, and you have the makful lahu, right? So, and the makful anhu, right? So these are concepts to be clear about. And then there are you have the kafala bin nafs, right? And you have the kafala bil mal, right? You can guarantee either the person, which is that you bring them to the majlis, right, for repayment. So you're not covering the debt. You just, that in the event of, you will bring the person to court for the payment, right? You'll bring the person to court for the payment. Or in the case of the kafala bil mal, you will cover the debt itself. You'll cover the debt itself. But the kafala bil mal, as we will see, it's not only when the asil, the person who owes the money, is unable to cover, but rather, let's say in the event of, Sidi Masir purchasing this house for, purchasing this residential property for X amount of dollars, the one owed the money can seek it from the kafil or from the one who owes the money. They can seek it from either one. And that's the even though the adab, the practical thing would be, who would you seek it from first?
Who is owed?
Yeah, the one who owes. But technically, you could seek it from the guarantor as well. It could be more convenient. And we'll see the fiqh of that coming up. Okay. Right? So he says, Kitabul Kafala, the chapter on guarantees. He says, Rahimahullahu Ta'ala, beginning with a definition of the terms. Right? He says, هي ضم ذمة إلى ذمة في المطالبة لا في الدين هو الأصح. It is to add one dhimma, one party to another in the right of demanding the debt. Not in the debt itself. That is the more correct opinion. So ضم ذمة, in adding one party, and that's the guaranteeing party. ضم ذمة, the first dhimma being referred to here, this is the dhimmat al-kafil. And dhimma Right? We said dhimma refers to a person, but it's the dues, right? It's as if it's a virtual container, right? So it's ضم ذمة إلى ذمة, adding one party to another in the right of demand. Adding a party, this is the kafil, to another, right? Which is the asil, the original debtor. And there's a good discussion on the dhimma here, right? The dhimma in the language means a covenant. And shar'an, it is mahallu ahdin jara baynahu wa bayna Allahi ta'ala. The self of the person, right? The self of the person, right? And moral responsibility is the amana. But the amana that is born, it's as if there's a container, there's a dhimma where your dues reside. Right? So that's, and we've talked before about the dhimma as well. That's just briefly. Right? But the guarantee is taking on, being asked for the debt. It is not taking on the debt. Who owns the debt? The original party. Fil mutalaba, right? In the debt being demanded of you, not in the debt itself, right? Right? Fil dain, right? So fil mutalaba, la fil dain, right? Such that because if it was in the debt, if you paid the debt, khalas, the original party does not owe the debt. Throughout, who owes the debt? Al-asil. The guarantee just gives a right of demand of the debt from the asil and from the kafil and from the guarantor. And this is the more correct opinion. And there's some discussion here, right, when it says fil asah. Why? Because this expression was used in the Hidayah, right? This expression here, fil asah or huwa al-asah. This is the more correct opinion. But the ishkal, the point of complication is that when you say al-asah, what does that imply about the corresponding opinion? You have the asah. What is muqabilul asah?
Weaker.
Yeah. Weaker. What's the Arabic of that? Muqabil. Yeah, muqabil of the sahih. The opposite of the sahih is, see Abdul Latif? Is da'if. Yes. Right? The opposite of the sahih is the da'if. If someone says, if they say, huwa sahih or fis sahih, it indicates that other opinions are weak. But when you say al-asah, the other opinions, what are they understood to be? Sadati?
Okay, but not as strong.
But okay, there's no category called okay. Huwa okay?
Hasan.
No, there's no expression. Qawlun hasan in fiqh. What's the term? See Abdul Latif?
Awsaf.
No. The other opinion, you have the asah, the muqabil al-asah huwa sahih. It's a sound opinion. But what is this sound opinion? So there's some discussion about this, but so this is why here the commentators on Majma' al-Anhur, right? So this is an important point, that when there's sahih, the opposite of sahih is da'if. But the contrary position to the asah is a sahih opinion. Because asah is more sahih, which means the other opinion is sahih. It is a sound opinion. So if you look at what the author of, what Imam al-Haskafi says, كما في الهداية. This is what the author of the Hidayah and other texts, they referred to it as being asah. But this would be technically problematic. Why? Because this is Zahir al-Riwayah, number one. Right? Right? This is contrary to Zahir al-Riwayah. And there isn't a sahih opinion within our madhab that the kafala is with the dayn itself. Right? There's no such position within our madhab. And when we discuss the sahih positions, we're not, the ulama don't go into what other madhabs say, because there's tafsil in other madhabs, but they don't discuss that. So, so there's tadabbur, right? There's tadabbur. The ulama use this expression because it was used. Fil asah, that the asah doesn't necessarily always refer to the position being in opposition to this being sahih. Right? So there's some discussion. So they say, that's why Imam al-Haskafi distances himself from it being asah, and has a discussion. Even Sheikh Zada problematizes the expression that this is not a terminological usage of the term asah. He says, هذا مخالف لاصطلاح الفقهاء فإنهم لا يستعملون الأصح في معنى الصحيح بل في مقابلة الصحيح تدبر. So he says, reflect on this. So it's a lughawi usage of the term, and there's some other nuances, but so this is what you should be aware of. ولا يصح إلا ممن يملك التبرع. Right? And guaranteeing is only valid for someone who can make tabarru'. Who is the one who can make tabarru'? Who can give a gift? They have to be morally responsible and free. And the one in debt, right? And then there's other categories, but they have to be mukallaf, so they have to be aqil and baligh, and they have to be free. So a child cannot be a guarantor for someone else. A wealthy child, could they be a guarantor? Could they be a guarantor, right, for somebody else? Can they?
No.
No, right? Because so a child technically cannot give gifts from their wealth. They cannot give away property until they hit adulthood. They say parents are allowed to let them give small gifts because that's part of their tarbiyah, to teach them to have generosity, but they cannot give, a child cannot make a sizable donation, for example, from their own wealth. Because لا يملك التبرع. Because the child, that's the reason they're not morally responsible yet, because they haven't got the maturity to think about their interests. Okay. وهي ضربان بالنفس وبالمال. وهي أي الكفالة ضربان أي قسمان بالنفس وبالمال. Right? The guarantee is either of the person or the property. So he'll first begin by explaining kafala bil mal, which is guaranteeing another person's appearance. Kafala bin nafs. So he says, فالأولى تنعقد كفلت بنفسه أو برقبته أو نحوها. I guarantee this person themselves or by his raqaba, In Arabic, the raqaba is literally the neck. We wouldn't say that in English. And the like of that. مما يعبر به عن البدن. With anything by which the whole body is referred to in Arabic. أو بجزء شائع منه. Or by a part of the whole. Right? Because they say ذكر الجزء ما لا يتجزأ كذكر كله. Mentioning a part of a whole that is indivisible is like mentioning the whole thing. Right? كنصفه أو عشره. I guarantee to bring a tenth of him. Can you conceivably chop off a tenth of a person? Permissibly? Or a third of a person? Of course not. So, therefore, if you guarantee to bring, I guarantee to bring him, to bring a quarter of him, you've guaranteed to bring him, as is obvious, right? أو هو علي أو إلي. It is upon me to bring him. For أنا زعيم أو قبيل به. Right? I guarantee or undertake to bring him. Right? So it's either the kafala bil nafs is either by explicit words of guaranteeing bringing the person for repayment, or that which is customarily used for that meaning. That which is customarily used for that meaning. Right? So that is kafala bin nafs. لا بأنا ضامن لمعرفته. But it's not considered a guarantee if you say, I guarantee that I know him. Because you did not undertake to bring him for the purpose of repayment. Okay. وصح أخذ كفيلين وأكثر. It is valid to take two or more guarantors, just as it is valid to take one guarantor. One can take multiple guarantors. In that case, the person could demand any one of them to bring them. So what is the consequence of kafala bin nafs? He says, ويجب فيها إحضار المكفول به إذا طلبه المكفول له. Right? So what is entailed by it is ويجب فيها أي في الكفالة بالنفس. In the kafala bin nafs, in the guarantee with bringing the person for repayment, is to bring the makful bihi, the person being guaranteed on behalf of, إذا طلبه المكفول له. If the one being guaranteed, who's the one who's making the claim, who is owed the money, requests him. Right? If they're sought. Now what if he doesn't bring him? فَإِن لَمْ يُحْضِرْهُ حُبِسْ. If he does not bring him, right? If the guarantor does not bring the person they guaranteed to bring for repayment, then they are liable to be detained. Habs. They're liable to be detained. But this is only, there are conditions here that are mentioned in the commentaries, right? They're liable to be detained. This is if it doesn't become evident to the qadi that it was not reasonably possible for him to bring the person. The person's hospitalized, for example, or the person has traveled, etc. Right? And the kafala bin nafs could be general, or he says, وَإِنْ عَيَّنَ وَقْتَ تَسْلِيمِهِ لَزِمَهُ ذَلِكَ فِيهِ إِذَا طَلَبَهُ. And if he specified a time in which to bring him for repayment, then that time becomes binding on him if the one owed demands that from him. فإن سلمه قبل ذلك برئ. And if he delivers him before that, then he's discharged his duty. Right? So this also can get complicated though, right? That's فإن غاب المكفول به وعلم مكانه أمهله الحاكم مدة ذهابه وإيابه. So if the one who's being guaranteed on, if the location of the makful bihi, the one who you guaranteed on behalf of, is known, like, so if they disappear, but it's known where they are, then the judge would give enough time to go pick them up and to bring him for the purpose of repayment. فإن مضت أي المدة مدة الذهاب والإياب, if the time passes ولم يحضره, but yet the guarantor did not bring him for repayment, حبسه, then the judge would detain him, right? Until he says, no, I will now go and bring him. وإن غاب ولم يعلم مكانه لا يطالب به. But if the one being guaranteed on behalf of, in غاب المكفول به, if the one being, who the guarantee is on behalf of, disappears and it's not known where he is, لا يطالب أي لا يطالب الكفيل, then the kafil would not be expected to bring him, because he's ajiz. He's only taken on the reasonable duty of bringing the person.
What? I'm looking for the right one. I only do one.
Okay. So this is, right? So this is not taking on more. Like, so the kafil bin nafs is only responsible for bringing him if it's within his reasonable capacity, right? Because the danger is that the guarantor, you said, okay, I'll make sure he comes to make the payment, but it's family. He knows that the guy can't pay, etc. So he doesn't do anything. Said, don't ask me. Right? No, you have to take responsibility for it. But all he has to do in the kafala bin nafs is to bring him for payment. If you bring the person for payment and then he doesn't pay, is the kafil bin nafs liable?
No, he's only responsible to bring him.
Yeah, he's only responsible to bring him to court, right? But people would have a sense of honor, not only of theirs, but of their friends and of their family. So they would feel shy to bring someone unable to pay, because it make you look bad, right? So it's a messy kind of situation, right? But kafala has consequences. So what invalidates the guarantee? وتبطل أي الكفالة بموت الكفيل. Right? The kafala is annulled by the death of the guarantor, والمكفول به, and the guarantee is made on behalf of the makful bihi, ولو عبدا, even if a slave. دون موت المكفول له, but the kafala is not annulled if the one owed the money dies, because it's transferred, because the debt then is transferred to the person's inheritors, right? The debt is then transferred to their inheritors. تماما. بل يطالب وارثه أو وصيه الكفيل, because in the event of the death of the makful lahu, the one you're guaranteeing for whom the money was owed, then the inheritor or their wasi, the one who's their guardian, would demand the debt from the guarantor. تماما. ويبرأ إذا سلمه حيث تمكن مخاصمته وإن لم يقل إذا دفعته إليك فأنا بريء. So the guarantor fulfills their debt of delivering the person they're guaranteeing if they deliver them in a place where it is possible to dispute with them, to litigate them, to dispute with them in court. This is all based on the person themselves didn't pay up. Even if he said that if I have delivered them to you, then I am absolved. Right? So, right? Because if you deliver them in a place where they couldn't do anything, right? So let's say a farmer sold you some land and you saw the farmer plowing their field, so you drag your cousin who owes him money. Here you go, but the guy's not paying. Right? Do we believe in taking the law into our own hands? So, farmer Ibrahim is plowing his fields. You brought the guy who owes him money to the fields. Can he have a court resolution in the fields? No. Right? So in the Kafala bin Nafs, you have to bring them to court, or to bring them to a place where they could then take him to court for payment. Because in the event of dispute, we cannot just take the law into our own hands. Either the issue is resolved without dispute. If it's not, then the matters are then settled in court by default, right? Okay. وبتسليم وكيل الكفيل أو رسوله. And the kafala ويبرأ كذلك, and he is absolved also if his agent, his wakil, the wakil of the kafil, the wakil al-kafil delivers him, or his messenger. The Rasul is someone who's carrying a message on his behalf, right? Who's carrying a message on his behalf. That also discharges him, because the messenger there is acting on his behalf. وبتسليم المكفول به نفسه من كفالته. Or if the makful bihi, or the one you're guaranteeing on behalf of, delivered himself, right, from the guarantee. So he showed up to the court date. Here I am. So if he showed up, then the guarantee to deliver him for resolving the case has been solved. Right? Okay. فإن شرط تسليمه في مجلس القاضي فسلمه في السوق قالوا يبرأ. So if the condition was made that he be delivered in the majlis of the qadi, he says قالوا يبرأ. They said that this absolves him. قالوا, who said this? Our three Imams, Abu Hanifa, Imam Abu Yusuf, and Muhammad, said that this is sufficient. They said, and this is the original position of the madhab, that it is sufficient. Right? But very often, qalu in this sense is used for what? To distance himself from this opinion. Right? But then he says, وَالْمُخْتَارُ فِي زَمَانِنَا أَنَّهُ لَا يَبْرَأ But the chosen position in our times, said the author of the Matan, Imam Ibrahim al-Halabi, is that delivering him in the market does not absolve the kafil bin nafs. And why is this? لِفَسَادِ الزَّمَانِ, due to the corruption of the time. And this was the position of Imam Zufar, right, who's the fourth the fourth of our great Imams, after Imam Abu Hanifa, Imam Abu Yusuf, Imam Muhammad. You have Zufar, and this is of the Masail where the fatwa is on the position of Imam Zufar. Who can recall another position in fiqh al-mu'amalat where the fatwa is on Imam Zufar's position? Does anyone remember? Selling the dar. What did Imam Abu Hanifa say? What is sufficient to see if there's a purchase of a dar?
See the courtyard.
The courtyard is sufficient. That's the position of all three of our Imams. What did Imam Zufar say?
See the inside.
Yeah, you have to see the rooms, right? The buyut, the rooms. And they said this is so the fatwa is in the position of Imam Zufar, but many of the positions of Imam Zufar, they say this is هذا اختلاف زمان ومكان لا اختلاف دليل وبرهان. واختلاف زمان ومكان, it's a difference of time and place, not a difference of evidence, of dalil and burhan, evidence and proof. Such that they would say, had Imam Abu Hanifa or his sahibain seen what Imam Zufar saw, they would have given fatwa as he did. Right? This is also the wisdom of the way of tafaqquh of Imam Abu Hanifa. Right? Tamam. So this is also, so this position, al-Mukhtar here, this is based on the position of Imam Zufar. تماما. وإن سلمه في مصر آخر لا يبرأ عندهما ويبرأ عند الإمام. And if he delivers him in another city, he is not absolved according to Imam Abu Hanifa, but he is not absolved according to the Sahibain, but absolved according to the Imam. Right? And they said that the fatwa here is on the position of the Sahibain, that would not be absolved. And there's an interesting position. This would depend from place to place. Imam al-Haskafi quotes al-Quhustani. And al-Quhustani, he's from a land called Kuhistan. It's very fascinating. What did Imam al-Quhustani do? What did Imam al-Quhustani do? What did he write? Anyone know? So there's an important work called al-Nuqaya. What is the Nuqaya? Sadati?
مختصر الوقاية.
Good. The Nuqaya is a mukhtasar of Matn al-Wiqaya. Because the Wiqaya the Wiqaya is one of the four mutun of the madhab. It gathered the masail of the hidayah, not the legal discussions, reasoning, proofs, etc. But it took the masail that are in the Matn of the hidayah, which is called al-Bidayah, took those and some of the issues that are within the hidayah itself, turned them into a Matn and tried to make it brief. But that was still relatively lengthy, so to facilitate its memorization, it was turned into a Matn. It's much more terse than the Wiqaya, and in our times the most famous commentary on the Nuqaya is, in our times, it's Fathu Bab al-Inaya by Mulla Ali al-Qari. But historically, the most famous of the commentaries on the Nuqaya, but that's, the Fath Bab al-Inaya, we used to call it FBI, right? By Mulla Ali al-Qari, is got the legal reasoning and goes into the proofs. And it goes into the proofs. But a legal commentary that goes into a lot of details and nuances is Quhustani. He goes into a lot of details, so sometimes the opinions mentioned in it are not strong. So it is a very important resource because it's full of nuances, a very important resource for fuqaha. But the untrained, who cannot distinguish between the strength of the opinions and so on, it is not a work you can rely on its own. But Imam al-Haskafi, an adept jurist, quotes from it, from a work, Al-Munya, right? And other books, that delivering to places where most of the judges are corrupt does not absolve one morally. Right? And he said, and then he has a lament. You can read the lament in Imam al-Haskafi. But the Kafala bin Nafs doesn't have a lot of applications. وإن سلمه في مصر آخر لا يبرأ عندهما ويبرأ عند الإمام وإن سلمه في برية أو في السواد لا يبرأ. But if they're delivered in the countryside, right, or in the Sawad, right, in the middle of nowhere, like one is not. The Sawad can also refer to the gardens, right? The in farming areas. And it's called Sawad because there's different reasons why it's called Sawad, because it's the agricultural lands. It's not absolved. وَكَذَا إِن سَلَّمَهُ فِي السِّجْن. If he delivers him in jail. Said, look, he's already in jail. Because if the guy is in jail, can he pay up in jail typically? No. Right? So the purpose of the kafala is not fulfilled. وَقَدْ حَبَسَهُ غَيْرُ الطَّالِبِ. If they're detained by other than the one seeking the debt. Because people also used to have private prisons. فَإِنْ كَفَلَ بِنَفْسِهِ عَلَى أَنَّهُ إِن لَمْ يُوَافِي بِهِ غَدًا فَهُوَ ضَامٍ لِمَا عَلَيْهِ فَلَمْ يُوَافِي بِهِ غَدًا لزمه ما عليه وإن مات ولا يبرأ من كفالة النفس. Right? So if he guaranteed to bring the person, right? So this is, you guaranteed to bring the person on, but with the additional provision that if he does not pay up tomorrow, then I will be a guarantor for him. So this is a double guarantee. It's a kafala bin nafs, that I will bring him for payment, but if tomorrow, i.e. when he brings him, he doesn't pay, then I will guarantee the payment. So this is a kafala bin nafs, followed by what kind of kafala?
Bil-mal.
Kafala bil-mal. Good. Right? But this would not absolve him of the kafala bin nafs when that happens, right? Because you cannot go back of the kafala bin nafs in this case. Okay. ومن ادعى على آخر 100 دينار بينها أو لم يبينها. Right? So if a person claims that another owes him 100 dinars, whether he brings proof, بينها أي أتى ببينة, whether he brings proof or does not bring proof, فكفل بنفسه رجل. So a third party took it upon himself, فكفل على أنه إن لم يوافي به غدا فعليه المئة. That if the person who owes the money does not pay it tomorrow, then I will pay it. فلم يوافي به غدا لزمه المئة. And then if the person who's owed the money does not pay it, then this third party owes the money. خلافا لمحمد, contrary to Imam Muhammad. تماما. ولا يجبر على إعطاء كفيل بالنفس في حد وقصاص فإن سمحت به نفسه صح. So one cannot be forced to provide a kafil in had punishments or qisas punishments, but if he willfully chooses to bring a kafil, it would be valid. وقال يجبر في القصاص وحد القذف, right? But the Sahibain said that it would be required in qisas punishments and the hadd of qadhf, right? But of course, the kafil here would be to bring the person to court, right? To bring the person to court. No, I mean, the punishment cannot be applied to a third party, of course, right? And the judge could apply this position to facilitate fulfillment. فإن شهد عليه مستوران في حد أو قود حبس. But if two witnesses in a had or punishment, had or qawad, make bear witness that what did they bear witness of? That there was a guarantor, right? That there was a guarantor. Then the guarantor would be detained. Detained till when? Detained until they brought the person who the punishment is due upon is brought forth, right? So what's the scenario? The scenario is that someone is liable for punishment, right? So there's a court case going against them. So someone says, look, let them go home. I guarantee that I'll bring them to court. And there's proof that he is, like, so in the event where he is not admitting to have been the kafil bin nafs, if there are two witnesses who will confirm that we heard him become the kafil bin nafs, then he has to bring, the person who the hadd or qisas case is running against, he has to bring them to court. If he refuses to, and it's known where the person is, they would be detained. وَكَذَا إِنْ شَهِدَ عَدْلٌ وَاحِدٌ. Likewise, if one upright individual bears witness. خِلَافًا لَهُمَا فِي رِوَايَةٍ. Right? And they said this is not really, the shahada here is not an actual shahada. Because an actual shahada, what does it require?
Well, I'm working.
Right? An actual shahada requires two upright witnesses. But here, the witnesses, the two witnesses, it's sufficient for them to be mastur. They're just confirming the guarantee. Or they're relating the guarantee. Right? So you need sufficient evidence. Right? And the threshold is lower here. Right? The threshold is lower here than it is in in other evidences, right? Because the purpose of kafala bin nafs is simply to bring the person to court. Right? And then the judge will verify the rest of the things, right? وصح الرهن والكفالة بالخراج, right? And one could take both rahan and a guarantee for the kharaj, the land tax as well, right? Because it is a debt that it can be payable, and any debt that it becomes due can be guaranteed as well. So this is about the kafala bin nafs. In the next part, we'll look at al-kafala bil mal, bi'idhnillahi ta'ala. So we'll look at that and the remaining section next time, bi'idhnillahi ta'ala. So we ask Allah subhanahu wa ta'ala for facilitation and success. Any questions before we close, Sadati?
I have a question.
Ji, go ahead.
This earlier when it says kafala bin nafs, then where you do the double kafala, there's something about the kafala still being upon the kafil even if he dies, or could you explain that again?
No. Even if he doesn't make the payment, right? So if the person says, I will guarantee him, I'll guarantee to bring him. And if he doesn't pay, then I will pay. Right? So let's say the person doesn't demand payment from him, because who ultimately owes the money?
The debtor.
The debtor. Okay? So Uncle Latif says, no, Masir Bhai, I don't want the money from you. I want it from the one who owes it. Is it his right not to demand it from the kafil? Yes. Or let's say the kafil doesn't have the money that day. The guarantor doesn't have the money that day. He's still liable to bring the person again. Right? Or if the day passes, right? The day passes. It says, he has to bring the person to court. Said, and if he doesn't pay, I will pay tomorrow. He still has to bring the person to court. Let's say if the court date is changed, etc. So basically, if the kafil bin nafs, if they take on after the fact, they take on a conditional kafala bil mal, that does not absolve them of bringing the person to court. That's the right of the person, right? They don't want, let's say the kafil is someone prominent in the community, etc. He doesn't want to, the one who's owed the money doesn't want to embarrass them, because bringing someone to court and demanding payment, it affects relationships and reputations, etc. No, just bring the person to court, and that's all I'm seeking from you. Mathalan. Is that clear, inshallah?
Who would be the fa'il of in matter?
Okay, so I mean that's the concept itself. In matter, we'll take that in the beginning of next lesson, because I've lost my place in the thing. We'll take that at the beginning of next lesson, inshallah. It's a good question though. We'll stop here, inshallah. Wa sallallahu ala sayyidina Muhammad wa ala alihi wa sahbihi wa sallam.